What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're still talking about the Karen Read verdict. We're going to talk about what happened with the false alarm verdict. We're going to talk about how it must feel for Karen Read and her team now after getting the good news. We're going to talk about Hank Brennan's reaction and how he argued for the sentence potentially for Karen Read on her OUI. We'll talk about some potential interviews and things like that. All that and more with Mark Bederow. So, Mark, it's over, man. It's over. We have a verdict. We have finality. Probably going to be the end of the road because of the verdict that it is, obviously being not guilty everywhere that mattered. What was your reaction when you first heard it?
Like a lot of other lawyers, I mean, not unexpected. It struck me and many others as always a reasonable doubt case. It was seemingly everywhere. But when you see it and it finally happens, and you have the what some people call the butt dial verdict before the actual you just at some point you scratch your head and say, this case, I mean, anything weird, odd, unpredictable, sketchy seems to happen surrounding this case. But the actual verdict, I'm not surprised at all. I think there never was anywhere near proof beyond a reasonable doubt. So I think they got it right.
Yeah, and I mean, you and I tried this case in a courtroom with a client nobody knows, we'd be supremely confident in a not guilty verdict with a normal jury and a normal prosecutor, normal judge, normal case. This was anything but normal. But I do think that you can start to understand, because some people, maybe including myself, the first trial, I didn't know anything about it going in, watching it the first time around. And we heard the defense was supremely confident in a not guilty verdict. That's why they tried the case the way that they did, called the witnesses or lack of witnesses that they called the first case, or limited certain parts of their case in chief because they thought they were going to win. They thought this was going to be a not guilty verdict because of everything they knew about the case. And I think we understand that. As trial 2 came, we understood this case is just different. So talk about the difference between being supremely confident round 1 and what they did versus maybe not as confident round 2 and putting on a more robust case, as they called it. And why do you think it worked?
Well, I think clearly they were confident the first time, but I think they were also confident the second time. The difference was when you have lawyers that are that skilled, that comfortable in their own skin, that confident, that they are willing and open to adjust, that, there's enough confidence in your own ability to maybe reevaluate and pivot and do things a little differently. And I think the biggest difference between the first trial and the second trial, you'll never hear me say trial 1.0 and 2.0. I can't stand that. But the biggest difference was going in on a classic defense, which is there's a burden of proof. They have it. It's substantially high, and they don't come close to meeting it, as opposed to the first time, where there were certainly arguments and evidence to support that, but many people felt maybe too far down the rabbit hole of assuming a burden in that, not legally, but, practically speaking in the eyes of the jury, by trying to establish what actually happened. And, there was a ton of evidence they offered, or the prosecution offered, and they certainly tried to exploit in the first trial, regarding 2 or 3 people must have done something in the basement. And you make that litmus test when you're the defense, and oftentimes that's just assuming more than you need to. So this time it was much, much more reasonable doubt. But I think most importantly, it was wrapped around science. And science in a trial, if you have it on your side, is always going to win, because you have medical science, engineering science, that's hard science, that's mathematics, physics, again, medicine, that's always going to win over video clips of, well, maybe I hit them, and witnesses with inconsistencies. And then the evidence that they had to kind of support the science supported the allegation that the police might have done something entirely sketchy. The prosecution didn't call Proctor. That was a gift. They chose not to call him as well. They didn't have to, obviously, as it turned out. But, they had two key civilian witnesses who were airtight. And if you believe them and believe they're credible, which I think the jury did, and they certainly seemed credible to me, would support the science by establishing she seriously was framed. I mean, there's no joke there. The officer Barros, no incentive to lie, right? And he makes it clear, absolutely not, that a taillight is not in the condition that the state police claimed when they found the car. Dogs are waking up. Sorry about that. Plow driver, who's just plowing the roads, says there's no body on the lawn. And without the science, that's still powerful evidence. But when you factor that in, there's no manner of death by the prosecution's own medical examiner. I don't see injuries consistent with the car accident. Two other forensic pathologists who say, I don't see any evidence of a collision, a car collision. One of them says, I do see dog bites. Another one says, I see animal bites. The prosecution expert says, I can't exclude animal bites. You back that up with, two PhD high-level engineers, one of whom focuses on the car and says, this is not consistent. Another one who focuses on kinetics and the movement of the human body and whatnot says, I don't see John O'Keefe's arm adding up. You pile that all on top of each other, and there's overwhelming reasonable doubt. And that's what they focused on this case. And it worked perfectly for them.
Yeah. And you and I talked a lot about, would you call this witness? Would you call that witness? Why would you? Why wouldn't you? And there was just a lot of thought around not overdoing it, but make sure you don't miss things that are really important. If you have something that's a gift like Proctor, maybe you use it. And I thought there's so many different domino effects you could talk about. Well, they could have called this witness, or they shouldn't have called this one, or whatever it may be. At the end of the day, with the verdict that you got, you don't second guess much, right?
No, I mean, look, who cares?
Exactly.
They won. So, and lawyers, this is what we do. We analyze, overanalyze. It's interesting. People care. At the end of the day, Karen Reed was acquitted of all these significant charges. So winning is everything in this situation. Again, as analyzing it, you can't help but wonder, right? And we're allowed to do that. And, if you saw the interview last night of Michael Proctor, all that did in my mind was embolden me and say, my God, I wish that guy testified, because he is just awful and did himself no favors. His demeanor was terrible. I think he was lying again on TV last night with some of his explanations. His body language was terrible. Would have been great to see, but you're right. This is a result-oriented business, and they overwhelmingly won. So it doesn't matter.
Yeah. Yeah. And a lot of times people say you pay for the result, but with Proctor, I mean, his timeline didn't match up with, when his text and how he said things developed. I mean, that was just a mess. We're going to talk about interviews a little bit later, but as far as the decisions they made, maybe one of the more surprising decisions, something they didn't do trial one, something people definitely disagreed with, I found it pretty interesting, was adding the OUI as a lesser included. She ends up getting convicted of the OUI, not guilty everywhere else, which is why we're talking about not guilty everywhere that matters. When you put forth something like that, it's easy to say, okay, you gave them something to convict on. And I think a lot of that comes from the research from the first trial, maybe the research from some people in the community, or, the public saying, well, to let her off scot-free when there's a dead police officer, or whatever, however you want to look at it. In my opinion, they pretty clearly found there was no collision between Karen Reed's car and John O'Keefe's body, and that Karen Reed's Lexus did not cause John O'Keefe to die. Like, to me, they had ample opportunity, even with maybe they didn't touch, because of the explanations and the way the jury instructions were written. If they felt like her car caused John O'Keefe to fall backwards in any way and die, they could have convicted her on something. They didn't, which leaves open the big question of the defense, and people in the defense's camp can still point to conspiracy, cover up, corruption, and the feds still need to do an investigation. I think Alessi, there's already a clip out saying, we know what happened. We saw the evidence up close and personal. There's no way this should be over. I've been saying maybe the feds can investigate the investigation again. I find it really hard to believe they're ever going to be able to convict anybody else of this unless they have some kind of a confession, because whoever else ends up getting investigated or ever charged would just point to Karen Reed as reasonable doubt. And maybe you can't prove it, but it's definitely something I think another jury would look at and think about.
Yeah, I mean, the irony is if somebody were to be charged, which I agree is unlikely, but I do think they should look into it. I mean, I have an idea of what, Bob is talking about and whatnot, and I get it. But if somebody were to be charged, first of all, it would never be in Massachusetts state court. That's
Right.
just certainly not under this district attorney, who will probably be gone in a few months, hopefully, anyway. But the incredible irony is that criminal defendant, if they hired lawyers like you or me, which obviously they would not do for a lot of obvious reasons, but if they hired lawyers, they would put forth a third-party culprit defense, and it would be a viable defense, and it would be Karen did it. And yeah, so if there were to be an investigation, it's already almost certainly lost, short of compelling proof, physical proof, that would be more than somebody saying, I was told by this person that they did it, or that kind of evidence, because this investigation was botched from the jump. And there is no viable physical evidence. There is no physical evidence that can be used against anyone else, because the Canton police and state police had no real interest in securing that evidence. If the feds are still sniffing around, that's fine. But, there's a large difference between the U.S. Attorney's Office and the Norfolk DA's office. I mean, the Norfolk DA's office, as you saw in this case, they think they have a hope and a prayer and a hunch. They just arrest and indict and say, what the hell? That's not how federal prosecutors run investigations. They don't indict or arrest unless they think it's airtight, meaning it's going to survive a trial, not let's see what a jury will do. I mean, that's kind of the fundamental difference. So, they should look into it. There's a lot of oddities, a lot of disturbing things, whether it relates to law enforcement, perhaps some other people, but to get justice for John O'Keefe by holding someone else other than Karen, now that she'll never be held responsible, rightly so, certainly in my view, I mean, I think the family is going to have to accept that the likelihood of ever getting answers is never going to happen. And it's certainly never going to happen if they remain aligned with the people that they're aligned with now. I mean, that's not a criticism as much as a reality. I mean, they're going to tell you Karen did it, and, the jury got it wrong and don't believe in conspiracies.
Yeah, I think the way that, they look at it from the outside and people asking questions like that'd be so unfair if they could use Karen Reed as a third party culprit, like you just said. But that's almost the definition of a third party culprit. You just take the Massachusetts State Police, Canton PD, Norfolk DA's file, and that's what you turn over to the judge as your evidence of a third party culprit. That is enough to point the finger at Karen Reed if you are another defendant to say it might have been her, versus we have a TikTok video and what they were trying to pull together for a third-party culprit falls way short of what they would have as far as the file on this case.
Again, you would have such an advantage if you were a criminal defense attorney representing, person X charged with something to do with the death of John O'Keefe. First of all, the advantage you'd have is every single person in Norfolk County, in fact, Massachusetts, the country, the world, knows what happened. They know that someone else was famously tried twice for this crime. Mm-hmm. And I mean, you could give an opening statement and just talk about the police. All they did was look at her, and here's why. And they found taillight, and they did this. And even though I don't think any of that is credible evidence at all, that other prospective defendant would have reasonable doubt as well and no burden of proof. And they would argue, look at all this evidence going in the other direction. And yeah, she might have been acquitted. I mean, the jury would have to know that. How could they not? Yeah. But the reality is it's not going to happen unless there is, video of somebody doing something or just compelling evidence that has not yet come to light. It's not going to happen because somebody says, hey, I was told by person Y that they were involved in this, and that's a basis to start doing anything. I just don't think it's going to happen.
Or one person flips and said, I lied. Actually, this is what happened. We did see John O'Keefe walk in the house, but I don't know what happened. It's like one eyewitness is not going to flip this. And again, I think the evidence falls so short of Karen Read as far as convicting beyond a reasonable doubt. And I think that any other defendant tried would still have potentially Karen Read's best piece of evidence, which was the horrible investigation and prosecution done of this case. So that would not change. They still just did not collect enough, did not record enough, did not produce enough records and chain of custody, and just everything that they did wrong in this case. Any other criminal defendant would have that same exact argument as well. And when it comes down to it, I think proving who ended John O'Keefe's life is something I would be very surprised if they ever really went forward on. But that doesn't change the corruption and cover up and maybe pin it on the girl type of evidence or planting of evidence. That to me could have legs if they wanted to investigate it.
I agree, but I do think you're never going to right the wrong of what happened and justice for all involved by charging someone else who's never going to get convicted. I think justice in this case, and this may not be how John O'Keefe's family and people who think Karen is guilty view it, but the fallout from this case and any sense of justice really has to be throw the bums out. I mean, goal number one should be get rid of Michael Morrissey at the ballot box anyway. He's got to go. I mean, the amount of resources he wasted on this, he still won't make any comments. There's no gag order. I don't think he should comment on the evidence. I get that. Case is sealed. It's not proper for a prosecutor to do that, but he still should answer the question of the taxpayer resources that he wasted on outside persons when he had an office capable of doing it. The state police, that whole unit, it needs to be fumigated. It's awful. I mean, the best practices of the Canton police, everything in this case was a disaster. And I think it is worthy of investigation, certainly finding out whether it's the feds. And I think, perhaps the proper avenue of investigation may very well be a 1983 suit. I mean, we'll see. And, they can certainly, Karen has the right to do that if it's a viable case against the government entities, and federal civil discovery in a case like that can be very telling one way or the other. And we'll see what she does.
Yeah, I think it'll be difficult. I mean, just because of the immunity involved and how those cases usually go, the high profile nature of this case would obviously help.
Yeah.
And obviously they have some resources over there, right? Because we just saw them spend over $1 million on this case. And frankly, it was almost more embarrassing for Morrissey than it was for Brennan, how all this played out when, like you said, the not free lawyers, but whatever they're paying their salaries, theoretically got more guilty votes than Hank Brennan did after all the money and time they spent on him the second time around. And they learned nothing. They should have just gotten rid of counts 1 and 3, and maybe they would have been better off to simplify it. They chose not to because they were trying to do everything they could to throw the book at her. Those are all decisions that come from the top.
They brought in Brennan ostensibly to be the shot caller, although who knows really. But the reality is, for somebody as experienced as he is, the decision-making, whether it was him or Morrissey in this case, was disgraceful in the sense what you just said. Forget, they went all the way seeking cert from the Supreme Court, obviously, on the double jeopardy issue related to the charge and the leaving the scene of the accident causing death charge. And whatever the law was, because the verdict was never published, I mean, for Christ's sake, we're all intelligent people and lawyers. They acquitted. Let's forget the legal definition. Every juror stepping forward is telling you we acquitted on those charges. Even the jurors who contacted the DA's office during that whole spectacle were saying that's all true. If you can't read the room and read the tea leaves on that and say that if this is about a fair trial and doing this right, maybe what I ought to do is try this as a manslaughter charge based upon drunk driving, out of control, recklessness. If you're going to try the case, I wouldn't have tried any of this. I wouldn't have indicted this. But if you're going to try it, that's obviously the charge. And they overtry it. They try to tell you, this is all about a fair trial. And then you see the lead up to the trial. I want David Yanetti's text messages because of a throwaway comment that Karen said, and you're thinking, this is gross. I mean, are you kidding me? No serious prosecutor would do that. You saw some of the pretrial motion practice. We're going to move to preclude your key experts over you didn't provide us a report or something when it turns out they did, that you claimed you got from the feds. And we're going to move to exclude every single expert you want to call on everything. And this wasn't a prosecution. It was a persecution, and it was a defense trying to prosecute. And just by simply saying, we want her to have a fair trial, but we're going to do everything in our power to prevent her from having a fair trial. And we're going to try to limit her from even defending herself. And she ought to try this case with one hand tied behind her back. And this whole process that you saw from the DA's office itself to when they, brought in a ringer to try the case to the completion of the case, this whole process was just gross. I mean, this was, a national spectacle, in my view, a national embarrassment, so many people watching. And that's why so many people were into this and out there, at the courthouse, and why this turned into a complete movement. They just see the awesome power of the state being exploited and abused to just get one person by any means necessary. And that's terrifying.
Yeah, and trying to block experts, trying to block her from the ability to even put on a defense, blocking her choice of defense lawyers when she wanted to add to her team because she had too many, and finding ways to not let that happen.
Yeah.
But I'm just saying, like, legitimately speaking, it was gross, which is why I'm going to play a clip here. I was surprised at this. I don't know why I was surprised, because this is what happens. And if you don't do this, it's embarrassing. But there were so many times throughout the process where Hank Brennan did something I was like, no way he's actually going to do that. And he did. So I'm going to play the clip, and then I want to talk about your reaction.
All right. So, Mr. Yannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend probation, 1 year, 24D program.
So the standard that everybody else gets on their first time OUI?
Certainly.
Okay.
We ask that she be treated no differently, no better. No
So I'm happy to do it. All right. Thank you all.
1 year probation.
I have thoughts about this, obviously. I watched this live yesterday with Melanie. And I said then, it's remarkable to me that the most human thing I've seen Brennan do from the day he jumped in until the very end, and the only magnanimous thing I think he's done throughout this whole process was at the very end, when he was thoroughly humiliated and vanquished, but finally put his sword down and basically said, let's end this. There's no need to have anyone come back. There's no need to argue for jail. And it was absolutely the right thing to do. It's interesting to note, even when he said that, David had to start arguing, not assuming the judge would go with it. And she had to cut him off and say, no, we're going to do it the first time. I mean, that's how programmed they were to believe that they were fighting, in essence, two prosecutors throughout this process. But, I did think—
Not even just that, Mark. Brennan was like, we're ready to go to sentencing right now. Yannetti's like, whoa. Let's go to sidebar real quick. I want to figure out what you're going to ask for before I agree to go into sentencing.
Yeah.
Right?
And I mean, now the cynic in me also says that one of the reasons Brennan agreed to this was to prevent himself the humiliation from coming back a week later and getting heckled and all of that. But look, it
hasn't stopped him before.
No, although this is now, this is humiliating. You just got a misdemeanor drunk driving conviction that she wasn't even charged with, that was specifically requested by the defense after 2 trials. And as you noted earlier, according to what we read previously, Adam Lally got 8 or 9 jurors to at least say she's probably guilty of manslaughter. And I think that analysis is a little simplistic and unfair. I don't think it means Adam Lally is a better lawyer than Hank Brennan. That is not true. That's not really the point. But, he did the right thing. She should have walked out of there yesterday with this behind her. There should be no week of thinking whether jail is an issue. So, I give him credit for that and nothing else, though. I think what he did throughout the course of this case was just disgraceful. And this was not prosecution. This was persecution. And, he keeps saying details matter, words matter. You keep saying you want to give her a fair trial. Words matter, but actions matter more. And you may have been saying, I'm trying to, protect her right, but your conduct speaks volumes. You weren't. And the gaslighting that went on throughout the course of his involvement in the case, I thought was just terrible. And, everyone involved with the prosecution in this case, they should have a lot of questions to answer. They just look terrible, and they deserve what they got. I mean, this is the right outcome.
Yeah, I thought he was a good loser. He lost like a gentleman. That's what you should do. Because I'll just tell you, he could have asked for jail time. He could have tried to come up with all sorts of aggravating factors. He could have done all sorts of things. And some judges would have looked down on you for trying that. I'm not so sure Judge Cannoni would have if he would have tried that. But when he asked for that, she certainly was not going to do anything else at that point, because then it would have just been a full-blown deal. But I did really appreciate that he did that in one sense. But in another, it reminded me just, again, the difference between a defense lawyer and a prosecutor. As defense lawyers, sometimes you go to trial knowing your client's probably going to get convicted, picking apart an investigation, maybe. You're not going to put on a defense. Your client's not going to testify. You're going to cross-examine witnesses. You're going to try to create or highlight reasonable doubt throughout the trial with this jury. And you go and you lose at the end, and you take your medicine, and then you go fight for sentencing and try to get them the most fair sentence you possibly can. And it's no sweat off. I'm amazed sometimes at how, people can argue with a straight face and pound the fist on the table. And, I've done it myself. I've watched my dad do it. I've seen criminal defense lawyers go into motion hearings knowing you're going to lose these, but arguing your butt off, and then you lose and you move on. And it's just part of life. It's our job as lawyers. That's almost what it felt like here for Hank Brennan, which is just not how prosecutors should operate. Prosecutors should not pound their fist knowing they're going to lose.
That, and one of the things that just shocked me, again, he's a very experienced, lawyer. He's been around. He's obviously tried a lot of cases, very comfortable in the courtroom. He knows how this works. And he's certainly smart enough to know that first and foremost, as a lawyer, and in particular a prosecutor, the guy in the white hat who has the burden of proof and has to lead the jury to the promised land beyond the wall of reasonable doubt, that nothing matters more than your credibility. And if the jury has doubts about your credibility, then your task is a lot harder. And I can't fathom that a lawyer of that experience and that level of skill and awareness would resort to, as the trial was ending, clearly, I got the impression he realized he was on the verge of losing. I thought his cross-examination started going down, just like, what I call, your questions get lazier. Not that he was lazy, but intellectually, the doubt is creeping in, your mind is doing things, and you just naturally start to flag a little bit. But beyond that, he was with a serious face asking about ham sandwiches and how long it took you to eat the ham sandwich, and Uber rides and limo rides and deleted messages about scheduling. And I'm thinking, this is a serious lawyer asking an engineer who was hired by the Justice Department before they ever knew who Karen Reed was. And what he's trying to suggest to the jury was that this guy, was basically an advocate for the defense. And he can't possibly believe that, especially when, dude, look at your expert. Okay. And the reality is, if you make like a winners and losers column in this kind of thing, once you get past Morrissey and Brennan and Proctor, the obvious losers, hello, Aperture, as a firm and their credibility, they're in the top tier of loser on this thing. But Brennan hired them. And that goes to his credibility too. Look at these people, the classic experts for hire, pay us to say anything and we'll do our best to fit the square peg in the round hole. And, that was a just colossal blunder, obviously. But, I think Brennan sacrificed his credibility again and again and again. And the jury, I think, sees that.
It's almost like he took this case knowing it was going to be an uphill battle, as if he was a criminal defense lawyer coming in. And again, I don't have any problem with any criminal defense lawyer representing the worst of the worst, coming up with an argument. If you got to go to trial because there's no offers, you go to trial. You talk about the typos in a police report. Can we really trust the rest of the work you did, officer? And those types of arguments. I just can't explain enough. And this case has been such a lesson to the world in the difference between what a prosecutor should be and what a criminal defense. Their jobs are different.
Yes, and he was so miscast. I mean, he, in hindsight, knowing his method, his style, everything you just described, why anyone would think he would be a good prosecutor for this case is mind-boggling. On the other hand, if he had been defense counsel in this case, and someone like Karen would never hire someone like him, but if he were a defense counsel in this case, I think he probably would have done a spectacular job,
Probably.
poking holes in the actual problems with the civilians, the corruption angle and that sort of thing. That's the irony is, if you got into this case on the other side, you would have been damn effective. But as the white hat prosecutor, oof.
Yeah, the sarcasm and the kind of like bully style cross, it can work sometimes. It really doesn't work with the witnesses he tried it with, especially Russell and Laposada and
immediately. Yeah.
Arca. Yeah, it really, he kind of picked his spots wrong. Which is obviously, it's very obvious at times when that happens, but I was really glad to see he did that with the sentencing. Anybody that handles any DUIs and you have first time DUI, it's like clockwork. Like you go, unless there's something crazy about the case, like it is what it is. And if you go to trial and you lose, you get this, and everybody knows that. And that's how it should be, because there was no death caused by this DUI. That was very clear from this jury. People are asking how this is going to affect the civil case. They didn't prove anything really necessary for the civil case to use as some kind of res judicata, meaning a decision that's already been made. Sure, she was drunk driving. You can use that in the civil case, but it doesn't prove that she actually hit him and caused his death. That's what you need to prove in a wrongful death case.
There's no causation of death. That's right. I mean, yes, they certainly have powerful evidence of intoxication and probably res judicata, I guess. I would even know to me on that issue.
The timing issue is something I would argue as a civil defense lawyer.
Exactly. Yeah. But even putting that aside, I mean, look, there's still videos of her drinking at the bar. Absolutely. There are the clips. So whatever. But, the people who are saying, well, the civil case and she's toast. Not at all. There's proof that she was intoxicated at a time the jury believes she was driving. That doesn't translate to causing John O'Keefe's death. And to the contrary, this jury found an ocean of reasonable doubt on that. Now, the standard's different, obviously, but, if you look at the evidence in this case, forget burdens of proof in a legal sense. If you had to come out and just say which side is more probable, like a more civil standard, right? Just, a preponderance, given the ARCA testimony, given the medical testimony, given the Barrows testimony, given Lawfren, vis-a-vis the prosecution testimony, although they had no burden of proof at all, I would say the preponderance of the evidence shows there was no collision with her.
So I've handled thousands of car accident and truck accident cases over the last 15 years. And I have never had a civil defendant even try to prove that there was no collision ever.
Right.
Ever. Never even seen that argument, because usually they can't. They don't even go that route. It's usually you're asking for too much money, right? That's 99%, especially the ones that go to trial. So I definitely think she could win at trial. But if we're talking real talk and we're just huddling around here and we're talking to Karen Reed, here's what I'm doing. I'm writing a letter to my insurance company saying, offer the policy. If they'll take it and go away, I'm not going to admit any wrongdoing. I want to be done with this. You guys are going to spend that money on this trial. It's going to be years of this. I want to move on. I want to do something else in my life than talk about this case. And I would have no problem with her doing that. I get it. Stand on business, justice, principle, all of that. But more and more years of heartache and misery versus the insurance you pay for, stroking a check, if they'll go away with that and they can say, we won on the civil standard, whatever. That's in real life. If it was me, I'll just say, if it was me, that's what I would tell my insurance company to do. But she's been through a lot, so I get whatever decision she makes.
What about this? If you're the O'Keefes, okay, do you want a few shekels with non-admission, or do you want, I want to play this out and get a finding for a sense of, you did it?
Yeah. I think that'll be a discussion with their lawyers, right? How much they think they can prove and what risks they want to take, and tell them, hey, there's a very real chance we go in and lose this and it gets even worse, versus she can say it's a non-admission all she wants, but what will people in the public think when she paid you money for ending John O'Keefe's life? You can spin this either way. Just like Hank Brennan right now on his website can go say, prosecutor Karen Reed found guilty on one of the charges. Bada bing, bada bang. Lawyers spin like nobody, right?
It's funny because, prosecutors do keep track of that stuff. Absolutely. I know this. Okay. I was that. But I will tell you this, no self-respecting prosecutor would ever go around and say, this was a conviction. I don't care that the jury said guilty of a misdemeanor drunk driving charge. You just tried the biggest murder case in the country that ended after a hung jury, and they specifically brought you in to bring home the bacon, right? And the only reason there was a conviction on a drunk driving charge is because the defense tactically wanted that as a potential off-ramp to lead the jury away from the indicted charges, and the jury did it. Okay, they took the off-ramp. But if you're going to walk around and say, I got a conviction, you need to get your head checked. This is an absolute, unequivocal, unmistakable loss for the prosecution. There's no way to spin this. They lost, period, full stop.
Yeah. I've seen lawyers post like, we won this motion hearing on the motion to continue or something. It's like, lawyers do stuff like that. So it is what it is. And maybe 10 years from now, Hank Brennan will put it up there like conviction or whatever on his website, but it's too famous. Everybody knows how this went. And with the context, it's definitely a loss. That's why people couldn't understand. And again, in the legal world and the lawyer world, the same thing. People are going to disagree with me about that civil side of the case, about telling, your insurance company to pay, but you got to realize these are people's real lives, right? We may watch it. For us, it's a job. We go into the office, we fight the case. And I tell clients all the time, do you want to file a suit? Do you not want to file a suit? It doesn't make a difference to me. I'm going to be doing this every single day, regardless, whether it's your case or somebody else's case, but this is your life. Here's what it looks like. Is this something you want to go through, right? Because there still is an aspect of stress and misery and the monkey on your back, to where if you can get rid of it all in a way that it's not going to change your life, you pay for this insurance, they can make it go away, and you can move on to something else. If it were me or if it was my daughter, I'd be like, let's just move on. Let's just move on. You've been vindicated. You've been exonerated. But again, you can't also blame them if they go the other direction. They're like, no, I want to continue to clear my name. Let's continue to fight it. People were always asking me, is she going to have the same lawyers? Unlikely, unless they want to or want to help or want to, advise. But usually your insurance company will hire lawyers of their own that they have on some kind of retainer. And unless you're going to pay private, individual, personal counsel yourself, the insurance company's not going to come in and hire Alan Jackson and Bob Alessi and whatever.
She's got the insurance lawyers on that lawsuit, which of course has been kicking around.
Right.
And that case, whatever, it is what it is. It's so small potatoes in the grand scheme of where we are. The only interesting thing about that case at this point is they can depose Karen now. That the Fifth Amendment cloak has been lifted. She's not in any legal jeopardy. So that'll be. And by the way, she's not bashful, so I'm sure she welcomes that. So I don't think it would be those lawyers for that. It almost certainly would be for if she pursues litigation herself. But that again,
Sure.
that's a whole nother story for a whole nother day.
Yeah, there's still the civil world is one that can last considerably longer than what happens in the criminal justice system. And there's so many different options because private people and lawyers can push that. And it's not, and again, that just, again, is a separation of what's supposed to be the protections of government and law enforcement and how that works versus civil, where like you can get sued for anything at any time if you can get a lawyer to do it. That's not how it should be on the criminal side.
No. And if they do pursue legal action, everything changes. And the biggest significant change is the forum. The days of Norfolk County Court and Canoni are over. You're in U.S. District Court in Boston filing suit, and that changes everything just in terms of, the whole Canton, Dedham, Norfolk County stuff, shenanigans, whatever you've seen. That'll be very different if that's the way this goes.
Yeah. Yeah. I do think there are issues, just the first trial with some people voting guilty and what they do have and don't have. They're probably, as much as the glass chart with Proctor, we don't need to get into that now, but there's a lot there, but it's so murky. It's just so murky when you go down.
It's so tough to get past. They get so much immunity. And also, the only thing that's interesting is, prosecutors, they do get some of that immunity lifted if they're involved in the, investigation, which usually would be, before an arrest. And in this case, the arrest came so fast. But by all accounts, the prosecution was heavily involved in every aspect of the case. And even after she was arrested, they continued the investigation. They upgraded the charges as the prosecution was investigating. And there were some real interesting arguments that could be made that the DA's office could be lumped into it and may not have absolute immunity. It's just, again, I don't want to get too in the weeds, but it is interesting.
To me, the thing that's interesting about it is the high profile nature. If this was Jane Doe and she called you and said, I got tried twice, hung jury, and then guilty on OUI, not guilty, you say, I'm sorry. It's just it's not a viable case. Like, if we're being real, right? But that's something that the high profile nature and the public push.
The game changer for me, again, this is so far speculative, but Barrows, if he told the truth, which he did, and if he was credible, which I believe he was, he didn't remember when he saw the photo. That's clear. He was wrong. Doesn't mean he's not credible, but he was wrong. But you can't believe both that Barrows told the truth and was credible, and that the state police did not plant evidence. Like, they don't go together. You kind of, if
I'm on the other side of that, though, I'm not sure it was the same strength or exact nature and comments the very first time they spoke versus how he was in trial this very last time. That's what you'd have to dig into more, I guess. But
again, civil discovery is a fact, well, more than me, is a fascinating thing. And what I go back to is Barrows's original report from that day does not appear to match what the state police said about the taillight. And Barrows testified as a prosecution witness after meeting with them, prepping with them, and they never asked him at the first trial after he said, well, there was a crack or whatever. They never showed him the picture, which is such an obvious thing to do, and say, is that what the taillight looked like? Because that would be devastating evidence against Karen. And they never did it. And then after the first trial, what does he do? This guy runs to the defense, basically. Throws himself to them and says, you saw when he testified how much he wanted to get this off his chest and how emphatic and emotional in some level he was. And, that to me, if you're thinking about like 1983 or whatever, about, planting evidence, Fourth Amendment, civil violations and all that stuff, that would get the gears grinding in my head as a major red flag to follow up on. Something's not right there.
Yeah, civil discovery settles a lot of cases because we're only talking about money, right? We're not necessarily talking about throwing somebody in jail or making sure a menace to society is out of the way. And it's like, if they don't want to turn something over, well, if you don't want to turn that over and I think I'm entitled to it, how much are we going to get to where we need to get to settle the case? And a lot of times it is if they don't want to turn something over. So again, maybe more unanswered questions. Maybe there will be some pressure points that can be pushed to get some kind of resolution done. But it's definitely going to be interesting. I think you mentioned the false verdict. I meant to ask you this. Have you ever had that happen before?
Of course not. I don't.
I haven't either. I didn't know. I'm asking everybody to see if anybody's had it.
I think you could ask every single lawyer in America who's living today, who's tried a case, criminal or civil, and you would have 100% say, once again, only in this case. That was comic relief. And most people immediately assume, oh my God, they're fixing this.
Yeah.
And then, you think about it for the 5 minutes, and then it occurred to me, we were talking about this as we were watching this in real time yesterday. This is probably that convoluted slip, and they submit it. They're done with the deliberations. And then somebody says, did we check the box right? Did we do, and you say, yeah. Well, oh shit. What if, forget it, do over. And they did have a verdict within like 3 minutes after, 5 minutes, whatever it was, which I mean, I don't think they were deliberating and changing. I mean, you're probably never going to see that, non-verdict, butt dial verdict, but it was probably confirming the slip. I don't know what else it could be at this point, but the way that played out in real time was just another complete black eye for how this case was conducted. I mean, we reach a verdict over lunch. We notify the court officer who takes the verdict, and the judge is like, well, it wasn't published, so it didn't happen. And you sit there and you say, well, what court officer? Who's watching the jury? What's in the slip? Where's that slip going? And you just say, why is everything about this case so sketchy? But it really, it encapsulates all the public's problem with this case. There's so much reason to doubt in the public's eye everything that's happened in this case for 3.5 years about fundamental fairness, shenanigans afoot, all kinds of things, that they see this kind of stuff. And your first instinct is they're doing it again. They're going to like put it on the girl again, as they say. And it really raises the larger problem, which is people have no confidence in how this case was investigated, how it was prosecuted, how it was adjudicated. I mean, it really raised a lot of eyebrows in a lot of people to say, this is why we support Karen Reed, because they do believe this could happen to anyone. For some reason, it happened to her, and just nothing is happening normal in this case. And that is true. Nothing about this case appeared to be normal or like you've seen anywhere else.
Yeah, I mean, there's a million different things and scenarios you can go through about what happened, but nothing was put on the record. Nothing was actually protected. So I do think we might hear about it. If any of these jurors get interviewed, I would think that's got to be one of the first questions. What the heck happened with that first verdict? Will they answer? Will they not? I don't know, but very interesting.
I can't think that would be one of the first questions. That's got to be numero uno. I mean, that is totally. And I listen. I think there are so many fascinating questions for these jurors, and I wonder if they'll be more apt to speak than the first jury, only because there's no controversy in terms of, oh my God, the jury. They sent no notes indicating we're struggling with each other or what to do. They sent a few notes. By all accounts, every single note had to do with the misdemeanor. I mean, we don't know
it made sense. The notes made perfect sense. Yeah. I had some lawyers texting me like, you never know, maybe juries are being coy and they're playing hide the ball. And I was like, it really is all pointing to, and it was like, oh, you predicted it, Peter, guilty on it's like the jury told us with the notes. Like, it would have been shocking if it was anything other than what it was based on all their notes, which to me is good. It's logical thought process, working through it like the jury, which you can understand how they get to not guilty.
I'm not in favor of the conviction on OUI. I think if it was standalone misdemeanor trial,
a great trial,
like you or me were doing, I think she'd be acquitted, no question, but forget that. But the best thing that happened in a jury deliberating for 4.5 days, they sent two specific notes about certain facts. They sent 2 notes seeking clarification on the messy legal instructions, and then they acquitted on 3 counts, but they did convict her of something. Anybody who is like, the jury is corrupt and unjust, get the hell out of here. They literally, if they did anything else, made it clear that there's no corruption in the jury. There's nothing in the jury process. They deliberated for 4 days. There's no controversy. They weren't, tearing each other's throats out over anything. They asked questions. They got answers. They came back and they gave both sides something, whether you agree with it or not. And that's the best way, for these, people, most of whom live, on the Twitter law school online, who complain about, oh my God, the jury was full of plants and this. The jury is the big winner in this whole thing because they did it the way you would want a jury to do it, methodically, carefully, professionally. And, it's tough to argue with the way they handled the process.
Yeah. And also just on that same line with, who could have been on the jury, a free Karen Reader or whatever, a diehard, probably would never have convicted on OUI, number one. Number two, most of my trials, I pick the jury in a day. Sometimes we'll come back the next morning with certain things and just confirm and swear them in. That's very different than the way the jury was picked in this case. So nothing should have slipped through the cracks on this case where you had multiple overnights to do more research. You can come back and strike somebody the next day you didn't think you were going to strike yesterday. I mean, they were digging in social media. So, I mean, this would have had to be somebody that really knew how to hide their tracks if there was something out there. Like, this was not just your average everyday jury where I'm picking a jury a lot of times and I try to dig in as much as I can. I always ask for more time, try to get them talking, try to build relational equity with them. But I know that I don't know everything about this person. They could be lying to me. This person's not talking enough. I don't feel like I have a good read. That didn't happen here.
No.
That really didn't happen here with these jurors. So I'd be surprised if there was some rogue juror.
No, I mean, I think, again, it's just Twitter law school chat more than anything. People, I mean, whatever your view of the case is, there's nothing at all to suggest the jury did anything other than carefully consider what it was they wanted to consider. And when you look at the notes, it seems clear to me, although you're not in the room, so you're speculating to some extent, that right away they were more focused on a misdemeanor and were ready to throw aside the car collision and the indicted charges. And what I found most fascinating about the notes was the note about the clips, because Brennan made that, the centerpiece of his case. And people like us were saying, that's like his strongest evidence. Not that it's that strong, but, it is what it is. And after 30 days of playing clips and arguing clips and using clips in summation, and the defense really taking the approach, yeah, whatever, just we're not even going to address it because it's meaningless. That resonated to some extent because the note from the jury was fascinating. Are the clips evidence? I mean, you want to talk about a kick in the nuts to the prosecutor, spend all this time, and the jury is like, does this mean anything at all? Like, what are those? Wow.
I think, is that where they called her Karen? The clips of Karen, are those evidence?
They called the defendant. They called her Karen and they asked if that was evidence. I mean, if you ever want to get insight into the jury's thinking, I think that was it. And I think they literally deliberated a freaking misdemeanor drunk driving case for 4 days and were ready to and that's why I think the other notes are like, well, what's the impact if we convict on the lesser? What does that mean about the greater? I think the only reasonable interpretation of that was we don't want to convict her of manslaughter and send her to prison if we just think she committed this ticky-tack drunk driving. So are we good with that, Judge? I mean, I think that's what it was.
Yeah, and I don't want to downplay drunk driving, obviously, and I know you aren't either, but it's important to compare what was being prosecuted and how we ended up here. That is really important, number one. Number two, I also think a couple things help the defense. And one of them is the length of the trial. I actually think helped them. The limitation of the closing argument, I actually think may have helped focus them. It forced Jackson to be focused. I mean, I don't think it would have been better if it was 2 hours. I really don't. I think he did it in the time period and hit everything he needed to. And it probably avoided them going down rabbit holes that they didn't need to go down, like the video clips that everybody wanted context for. But a lot of those were months ago, right? A lot of the Commonwealth's best evidence was months ago. And it's like, so, and passing on the rebuttal, I mean, that was just like they ended with days and days and days of good evidence for the defense. And also another good thing I think for the defense is you had a good jury in that we've had juries before where I think they have hated the government so much for bringing these charges against our client to where they're just like a quick not guilty down the board. They probably didn't even read the elements. They were like, we don't care, not guilty, not guilty. They didn't. They went through, they read each different definition because they probably came to the agreement that there was no collision. She didn't cause this death, which they could have just checked not guilty everywhere and been done. Instead, they were like, let's really consider this OUI charge because it doesn't have to involve a collision. It doesn't have to involve Karen Reed's Lexus and John O'Keefe's body at all. Let's really consider this. And I respect them for that.
Yeah, I mean, I think the length was fine. I mean, it was good to see the judge at least give them more time and then not interrupt when they did go over. I mean, that was truly embarrassing at the first trial. I mean, I don't have much I have very little sympathy for Adam Lally, except for one thing, when he was trying to finish and she's telling him to wrap it up and he's saying, can I finish my sentence? I mean, that was just, I thought that was gross, and I don't particularly like what he did, but so I think the length was fine. On the other hand, when you have, an orator and a skilled advocate like Alan, I don't think an extra 30 minutes would harm the jury. I mean, I think he had the meeting
It's
out
true.
of the
It's true.
but I also think, like you said, the way the case ended, the case could not have ended with any more momentum for the defense. I mean, piling unimpeached expert after unimpeached expert, and then, the prosecutor just capitulates and abandons a rebuttal case, which tells you a lot of things. Number one, it tells you, Aperture, who was supposed to be the anchor to their case, the expert who's going to bring it home, was a colossal waste of money, that it was so bad and they were so eviscerated to the point where I can't even recall this guy, or I should say, I've always felt that one of the reasons Brennan abandoned a rebuttal case was to save his own rear end personally, and almost created, in my mind, whether he had a conflict between himself and the case, representing the DA's office. Because if you recall Welcher, the x-rays, that's an issue. If you recall that Maureen Hartnett, she's the one who cut open the hoodie. And I mean, you can talk me out of this, or you can try. I don't think you can. I think at that point, that was self-interest, that I can't do this because we knew she cut those. And I can't explain that in the context of the stunt that I tried to pull. And as far as the x-rays, we did have x-rays. They were from the autopsy. We turned them over to the defense. This guy says, I looked at x-rays, but not the most important one. Did he not give that to him? Did he tell him it didn't exist? I don't know, but he just abandoned the case, that he kept thumping his chest out saying, I'm going to do this, I'm going to do this. And he didn't. And I just think, you look at all of this and you see, this is why all of this was just a complete disgrace. I mean, this was such a misallocation of resources, a waste of time, and in my view, just an unjust proceeding.
Yeah, and I think now it's kind of like, what happens next? Immediately, there's going to be some interviews, right? There's going to be some things happening publicly. I did not expect the first interview to be Michael Proctor. I did not see that one coming. The Alberts, I think, was it the Alberts or the McCabe's, or a combination of them, made some kind of a statement. And again, pushing that this happened because of, media pressure and other things, and nothing to do with the evidence, et cetera, et cetera. Do you expect more of that from the prosecution side?
Well, it's clear that the people speaking out on that side lack any common sense understanding of public relations, and certainly do not have a PR advisor on retainer. I mean, you start with Proctor, who, by the way, is going to be doing another one on Dateline. So he went on the press tour. And you wonder, is that why Brennan didn't call him? Because all of a sudden my argument about Karen making clips isn't so compelling when Proctor's out there saying stupid things. Who knows? But Proctor's interviews were terrible. We can get into detail with that. The statement by the Alberts and McCabe's was a failure in PR 101. First of all, instead of just saying a statement from, the McCabe and Albert families, they specifically listed the people, and they went up and down the people whose names everyone knew. And, the first sentence they say is, we're thinking about the O'Keefe family. Perfect. And our thoughts are with them, and we'll support them. Okay, do that and sit down and get out of there and be done. But then they go on saying, we're not going to say anything. We'll have much more later to say. And then they say everything.
Mm-hmm.
They say, Karen, her sleazy lawyers, the sleazy internet people, maybe you too, all these other people, who knows? And all these people and conspiracy theorists, they just can't help themselves. And it's just such a foolish statement to make, because all it does is invite, like something I said yesterday on Twitter about it was, 4 of the people who signed that statement were in a family group text the days that this happened, like in early 2022. And they weren't talking about John O'Keefe. They were talking about the guy who we have to tell the press didn't go in the house, the guy who we're finding out who's saying what and celebrating and giggling when Kerry Roberts is telling them everything. Another signatory to this, you know, a signatory to that statement, lied to the FBI and then shut it down. A signatory to that statement absolutely materially and intentionally lied to the grand jury. I'm not going to call it perjury because I don't think it ever will be, but they just maybe show sympathy for the O'Keefes if that's your position, but spare us the other stuff because it's going to come back and haunt you. And, you know, it's one thing to say how outraged we all are, you know, other than Jennifer McCabe and Kerry Roberts, none of them testified. I don't know why that is, you know, for the prosecution, but I thought the statement should have just said, if you're trying to support the O'Keefes, so support the O'Keefes, but turning this into, you know, screw Karen and her dirty lawyers and people on the internet and who say that, you know, anything happened. There are reasons why people believe Karen was framed. There are reasons why people believe that there is evidence to suggest that other people were responsible for this. And that evidence was admitted in court. So I don't know what these press tours are doing for them. I think the best thing for them would be just kind of fade away and hope it dies down. And, you know, obviously nothing happens with any other investigations.
Yeah, I'm really surprised. I think they should probably relax. Might be the best advice. But we know the defense side is going to go out and give these interviews, which is probably going to make them want to speak out even more. As we saw Paul O'Keefe after the last trial give that, you know, big interview, which I was also surprised about. What do you expect from Karen Reed's team? I know her family members have kind of gone and given some interviews already outside the courthouse steps, outside their house. Do you expect kind of the old-fashioned tour where Good Morning America, whatever? Do you expect things like that?
I would expect all hands on deck everywhere. I mean, Karen's been smeared for 3.5 years, and I get it. Some people think she did something, and that's fine. But, you know, we're in the age, again, of Twitter and social media, and she has just been kicked and kicked and kicked repeatedly. Her lawyers have been smeared. Her parents have been smeared. And I would expect them to push back and, you know, to try to, for her sake, restore some of her reputation and establish whatever they can. Now, whether that's a future investigation or just explaining what they feel needs to be said, I would expect classic media, like you said, but I would also think, given the way things are now, some of the modern media as well. I mean, it's out there. So I would think they would be talking a lot. I would think they'd have a lot to say about the DA's office. I think they would have a lot to say about how they felt they were treated in court. You know, we'll see. I mean, it's up to them to decide. But I mean, I think most observers think they weren't treated fairly, but, you know, in terms of being in the courtroom, or at least there was a perception of that based on a lot of reactions. And, you know, that harms her reputationally across the board. It harms the lawyers too. I mean, the lawyers were smeared and then they were gagged. And, you know, if I'm a lawyer whose ethics have been attacked unfairly, and then I'm gagged and I don't even have a chance to talk about it, as soon as I'm ungagged, I want to talk about it.
Oh yeah, big time, and publicly reprimanded multiple times. And
Yeah.
that can follow you, right? I mean, we've seen some high profile lawyers where the lawyers against them in certain cases will cite to cases where the judges have publicly reprimanded them or reprimanded them on the record. And I would expect that to happen with some of these lawyers who are going to be high profile. They're going to be in some nasty battles in the future, I'm sure, where this will come up again. So, you know, I wouldn't hold it against them if they did want to talk about those things, but it also wouldn't be surprising if they picked and chose kind of their different spots to take. And the interesting thing about modern media versus, you know, classic is the classic stuff is usually a lot shorter, a lot quicker, a lot news bitier. And,
Yeah.
and if they can get into the modern stuff and really dig in and have longer conversations, I would expect those to be really, really telling conversations. I really would. So the last thing I want to ask you before I let you go is, what's next for you? Are you going to talk about more cases? Are you going to kind of just go back into practicing law, just practicing law as a lawyer? Or do you think you'll, continue to scratch the itch of talking about these cases?
I mean, we'll see. I mean, I've done over the years a lot of, classic media legal
Right.
analysis, but that's, a reporter from the New York Post calling about a comment about a case.
Right.
That's
Very different.
Very different than really digging in. I don't know. Obviously you got to keep the lights on, as they say, and earn a living regularly. I've got a couple of big things that are still cooking that obviously will take up most of my time in that regard. But I think it's a pick and choose. I am really tempted because of the cast of characters and what I believe is absolute corruption in the state police in that area and Norfolk in particular. I'm really tempted to dive into that Sandra Birchmore situation. Part of me, the left part of your brain is saying, "Don't do it, don't do it, don't do it." But the angel and devil in the cartoon show.
Yeah.
And the other side is saying, no, get like something is
So
off here.
unbelievable. It's truly unbelievable.
So I'm kind of thinking about it. So yeah, no, I'll stick around.
Good. I hope you do. And I hope to have you back on whatever case it is you decide to dig into. I'd love to talk to you more about it. I've really enjoyed it, Mark. I appreciate you coming on, taking the time to break down these cases.
Anytime.
All right. Well, that's all we got. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.